Good morning, children. How are you? Okay. I hope you are, or you must be making most of each time when you do have enough time because you don't have to go out and you can really devote yourself for the sake of your bright future. Fine, children. So, in today's class, or before going to today's class, let us just see which all topic we have covered so far. Fine. Any one of you can tell? Okay, I'm going to tell it once again. See, we have discussed about the structure and hierarchy of courts in our country. We have discussed about Supreme Court of India. We discussed about High Courts of India. We discussed about District Court and Lower Courts of India. Municipal Courts of India we discussed. We discussed about tribunals, and then we discussed about salient features of our judiciary and the legal officers, the first legal officer, law officer of our country, about the attorney general and other law officers. Like in a state, in a province, we do have the advocate general as well. And then yesterday we have finished independence of judiciary. How independent and till what extent judiciary is independent in our country. We discussed that in detail. Fine. Let us move today toward, towards different roles of the Supreme Court of India. Part 1 we will discuss today under this different role. In these different roles of Supreme Court of India, basically what do we say, or when we go to the roles of Indian judiciary and particularly the role of courts. See, as we know, Indian judiciary comprises of Supreme Court, High Court, subordinate courts and the other tribunals. About all these we discussed here. Particular their specific role we are going to discuss here, children, and the role of these courts. Okay, the role of these courts along with their composition, their powers and proceedings for functioning have been elaborated in the constitution. At length, in detail, it had been discussed, it had been explained, it had been penned in black and white, written in black and white in our constitution, so that tomorrow no one should get confused. No one should tell that I don't know what does this tell, what does this mean. Fine, children. So, under this different rules of the Supreme Court of India, Supreme Court of India primarily exercises the role of an adjudicator and along with adjudicator, interpreter. Means it's adjudicates, Supreme Court adjudicates, Supreme Court interprets. In case of lack of clarity, Supreme Court throws light on it. Means interprets. Adjudicate means these all come under within the jurisdiction of the Supreme Court, and whatsoever will be opined by the Supreme Court, every organ they need to abide by it, they need to obey. Fine. So the role of Supreme Court as an adjudicator and interpreter further can be understood through the original and appellate jurisdiction vested with the court. Supreme Court does have original jurisdiction, means originally the all rights that lie with the Supreme Court. Okay, that comes under, or that is known as the original jurisdiction of the Supreme Court of India. Fine. And we do have the appellate jurisdiction, means through appeal, through the process of appeal from the lower court, from the district court, from the higher court, one by one. Okay, channels are there. By following those channels, they move ahead. In our constitution, children, we do have one dedicated article 131. Under this article 131 of our constitution, the Supreme Court is granted original jurisdiction. So what original jurisdiction, children, we are discussing here? Credit goes to article 131 of our constitution. Clear? And this power is exercised to adjudicate amongst disputes between union government, between the central government and the state government, between the union government or more states, more than one states, between two states government, between two and more states government. Fine. And such disputes, children, here you need to understand it. Such disputes must involve some question of law. It must not be only for the namesake, okay, or fact on which the existence or extent of legal rights can be adjudicated. Only for the false pride, for the namesake only, if anybody approaches, any organ approaches, any wings approaches, any institution approaches, any individual approaches, then Supreme Court does have the right to punish them as well. That's why what is most important, that such disputes must involve some question of law or fact on which the existence or extent of legal rights can be adjudicated. Like, for example, the dispute between sharing of river water, like we have seen in case of Tamil Nadu, Karnataka, and Kerala. Basically, Tamil Nadu and Karnataka. Kaveri Water River. We do have a river tribunal, Kaveri River Tribunal, children. Okay. In that case, again the water dispute we do have between the Punjab, Haryana, and Delhi. Isn't it? Recently we had this case as well. So, be that the water related issues, sharing of river water, or other natural resources between two states in India, all these things can directly be brought to the Supreme Court under existence of its original jurisdiction. Clear children? Any doubt? Okay, fine. Now, one such article we do have in our constitution, that is Article 32. This Article 32 of our constitution further gives an extensive original jurisdiction to the Supreme Court. So under Article 32, we say it extensive original jurisdiction to the Supreme Court for what? For enforcement of our fundamental rights. Yes, children, fundamental rights of the citizens of India. And how does and how can Supreme Court do so? Through issuing directions, orders, writs. We have discussed all these things in detail in last class also. So, by issuing directions, writs, orders, how many types of writs we do have? Okay, 5 kinds of writs we do have. Very good. Okay, can anyone say the name of these 5 kinds of writ? Habeas corpus, mandamus, quo warranto, certiorari, and prohibition. Very good. These are the 5 kinds of writ. So, this is popularly known as the writ jurisdiction of the Supreme Court. Fine, children? Okay. Now, the appellate jurisdiction of the Supreme Court. It can be invoked by a certificate. What certificate is required here? Certificate is required by the High Court. Means a certificate must be issued by the High Court, then only someone can approach the Supreme Court of India under this appellate jurisdiction. And appeal to the Supreme Court may be made against any judgment, any decree, any order, any final order of a High Court in both civil cases and criminal cases. Be very clear. It is not only criminal cases matter will go to Supreme Court, or only civil cases, in both the cases. Recently, children, we have seen the hanging of all the in fact names are, or the words would be very less for all these culprit in the Nirvaya case. We have seen that once they are going to the Delhi High Court, if they are getting the verdict against them, they are moving to the Supreme Court. So it must be certified, but at last they had been taken to task, and all these we can say the criminals of humanity, they had been hanged, they had been taken to the task, children. Okay, and this must be a lesson for all others who ever think in that direction. Fine. So, appeal to the Supreme Court may be made by a certificate or through a certificate granted by a high court, and further this appeal certainly may be made against any judgment, decree, final order of a high court in civil and criminal cases. And like the exercise of original jurisdiction, all these cases must involve substantial question of law. There must be some fact. Okay. As to the interpretation of the constitution, if there is no fact, it's useless, and that will be the wastage of sheer wastage of time, okay, of our judiciary, and it will be unjust to the millions of people living in our country who had been waiting for the justice to be given to them at last. Okay, so substantial question of law, as highlighted above, as explained above, it cannot or it connote questions of law or fact on which the existence or extent of legal rights can be adjudicated. It must be some real fact, some real issue that needs to be addressed by the highest judiciary of our country. Okay, children? It must not be that, okay, because for simply taking the revenge for wasting the time, as we saw in this Nirvaya case, I am going from High Court to the Supreme Court. Okay, and apart from all these appellate powers of the court, the Supreme Court is also vested with wide appellate jurisdiction. And we do have one dedicated article in our constitution. That article is Article 136. It is wide appellate jurisdiction all over the court, over all courts and tribunals. Okay, under its discretion, the court may grant special leave to appeal. Any special leave may be granted, or receive any judgment, any decree, any determination, any sentence or order in any cause or matter passed or made by any court or tribunal in the territory of India. Did you get it? Okay, I'm explaining it once again. Under this wide appellate jurisdiction, means Article 136, the court may grant special leave to appeal. Special leave, a special time would be given for appealing, to appeal and receive any judgment, or for getting the copy of the judgment, decree or any determination or sentence or order in any cause, in any matter passed or made by any court, passed or made by any tribunal in the territory of India, within the territory of India. Okay, I hope I am clear. Now, we do have another such article, that is Article 143. Means apart from this being an adjudicator, interpreter, Supreme Court also functions as an advisor. Fine, children? And this court's advisory jurisdiction may be sought by the President of India. This is dedicated article, as I told, Article 143. Okay, when court's advisory jurisdiction is being sought by the President of India, this entire procedure is known as, this entire procedure is termed as presidential reference, and it is recognized by the advisory jurisdiction of the court. Got it? So, under this advisory jurisdiction of the court, presidential reference, okay, we know that entire process is being followed, and under the same scheme, under this scheme, President may refer any question of law or fact of public importance. President may ask. President does have this right to ask, but it is not binding on the Supreme Court. Remember one thing, it is not binding on the Supreme Court to answer questions raised in the reference. Okay, and in the last 60 plus years, only a handful of references, few references have been made so far, and the Supreme Court can refuse to provide its advisory opinion if it is satisfied. Supreme Court may refuse also, children. So, Supreme Court may refuse to give its advisory opinion if Supreme Court is satisfied that the questions are either socio-economic, or political in nature. If questions are social in nature, if questions are economic in nature, if the questions are political in nature, Supreme Court may refuse to provide its advisory opinion. Fine, children. If Supreme Court wants to give opinion, it's free to give, but Supreme Court cannot be forced. Clear? Fine. Any question you want to ask? Whatsoever we have discussed today, children? No? So all these things under the Supreme Court, role of the Supreme Court of India we have discussed. Okay, they are part 2 along with the public interest litigation. Okay, the concept of locus standi in a civil society. Fine, we will discuss it next day. Public interest litigation, we also say social action litigation, and for that the term exactly in Hindi is Janhit Yachika. In detail we have to discuss, we will be discussing. Fine? Okay. Hope you must have enjoyed the lesson. Take care, stay safe, stay indoor. Thank you.